Welcome back to The Deep Dive. We're your hosts digging into the complex world of technology.
Great to be here.
Today, we're taking a really close look, like a high-resolution snapshot at the intense legal warfare that's currently ripping through the AI industry.
Yeah, it's pretty fierce right now.
We're focusing squarely on these major battles between xAI and OpenAI, the ones really defining the future competitive landscape.
And specifically, the tech side of it all.
Exactly. Our mission today is, well, highly targeted. We want to cut through all the personal stuff, the corporate drama.
Which there's plenty of.
Oh, yeah. We want to analyze the purely technical and competitive implications. What's actually in these lawsuits from a tech standpoint.
Right. We're talking about highly specialized trade secrets, the kind that are really hard to define sometimes.
And this brutal talent war for AI engineers. Plus, the legal precedents being set. These are huge for AI intellectual property.
What's really fascinating, I think, is how these court documents, the filings, the counterclaims, they're giving us this unprecedented window.
A window into what?
Into the technological secret sauce.
Yeah.
What actually drives advanced AI development today.
So it's not just about the personalities or the money.
Well, the money's there, obviously. But fundamentally, this is a technological inflection point. The legal system is really grappling with the unique nature of proprietary source code and things like advanced infrastructure design.
Okay, right. Let's unpack this rivalry then. We need to establish the foundation of the conflict first, I think.
Makes sense. It all stems from the very beginning, doesn't it?
Yeah, the initial founding and then that big split over their core mission. OpenAI, it was founded way back in 2015.
Seems like a lifetime ago in AI years.
Doesn't it? And it had a very clear, stated goal back then. Develop AI safely, responsibly. It was primarily a nonprofit.
And, that mission held up for a while. But the sheer cost, the financial reality of trying to scale AGI development, it's astronomical.
Right. You need massive resources.
Exactly. So fast forward to 2019, and the whole structure fundamentally shifts. They needed a huge influx of capital.
That's when they moved to the capped for-profit structure.
Precisely. OpenAI transitioned. And this pivot, well, it happened after Musk had already left, citing potential conflicts with Tesla.
Right.
But that change became this sort of philosophical tinderbox for the legal fights we're seeing play out right now.
And Musk did sue over that initial mission change, didn't he?
He did. First in February 2024, then he actually withdrew it.
Which was confusing at the time.
A bit, yeah. But then he refiled a very similar lawsuit in August 2024, the core allegation. That OpenAI completely deviated from that original nonprofit mission.
And that suit's still active.
Well, very much so. It's not fading away. Judge Yvonne Gonzalez-Rogers, she's officially set a jury trial date, March 16, 2026.
Wow, okay, so that's locked in.
And it's a really significant move. It shows the court wants a, relatively rapid and comprehensive ruling on this core question.
Yes.
Can an organization just fundamentally change its founding charter, its core mission, especially when the technology it develops suddenly becomes immensely valuable and profitable?
So this whole institutional pivot from, let's say, mission first to for-profit dominance, that's the philosophical backdrop.
Exactly. It sets the stage.
And it kind of explains why the technical competition has gotten so, desperate.
Right. The stakes are incredibly high now.
This transition sets the stage for where the real technical battle is happening right now, which brings us to that September 2025 AAI lawsuit, the one about alleged trade secret theft.
Okay, yeah. This is where it gets really technically interesting.
You think so?
Definitely. This lawsuit is the technical heart of the whole conflict. xAI is alleging systematic theft of proprietary information.
How?
Essentially, they're accusing OpenAI of engineering an unfair advantage. How? By unlawfully poaching former xAI employees.
Who allegedly brought sensitive data with them.
That's the claim.
Yeah.
That they didn't come empty-handed.
And the technical secrets allegedly at stake, that's super specialized, right? They point directly to where the real value in AI lies today.
Which, as you said earlier, isn't just the model weights themselves.
No. So the first big proprietary claim relates to their Grok chatbot technology. We're talking specific source code, operational advantages around the Grok model, particularly Grok 4.
And xAI is asserting that Grok 4 is now matching or maybe even surpassing some OpenAI models in key performance metrics.
Right. That's a big claim.
It is. And this is the critical distinction I think we need to make clear for, for listeners. A modern LLM, like Grok, it's in so much more than just its learned parameters, the modern weights.
Okay. Explain that a bit more.
Well, Anyone with enough data and enough compute power could theoretically train a roughly equivalent set of weights, maybe.
But
But the proprietary source code, that's the highly optimized engine. It's the software that takes those weights and makes them run efficiently, cheaply, and at massive scale.
so like the plumbing around the brain.
Kinda, yeah.
Yeah.
We're talking custom code for things like inference optimization, specialized memory allocation routines, highly efficient distributed systems frameworks.
Okay, low-level stuff.
Very. That's where the millions, maybe billions, in specialized R&D are truly embedded, not just in training the model.
Help us understand this better. If a competitor, say, somehow got access to the model weights, why is that surrounding source code potentially more valuable?
Great question. Because without that specific proprietary surrounding code, the architecture, the specialized drivers, you simply can't deploy the model efficiently.
Oh, okay.
You might have this brilliant AI brain, the weights, right? But without a perfectly optimized nervous system, that source code, it could cost 10 times more to operate.
It would run slower, crash more?
Exactly. It wouldn't scale.
Right.
The code, that's the real technical moat around the AI model itself.
Interesting. Okay, and the second major claim, this one's fascinating too. It's pure infrastructure IP, data center strategy.
Yeah, xAI refers to this as their secret sauce for deployment.
A secret sauce for data centers. What does that even mean technically?
It means the IP conversation moves beyond just software. It goes into hardware optimization, physical layout, network architecture.
Right, because when you're running AI at this enormous scale, every tiny fraction of efficiency matters. A tenth of a cent per query adds up fast.
Precisely. So proprietary data center strategies could involve specialized blueprints for cooling systems, highly customized networking configurations to minimize latency between maybe thousands of GPUs.
Like how the chips talk to each other really fast?
Exactly. And unique power management systems, optimizing that PUE, the power usage effectiveness. This architecture isn't off the shelf. It's custom built to run their specific models in the most cost-effective way possible.
So stealing that deployment strategy.
Is potentially stealing billions in future operational savings. It's a huge competitive advantage.
Okay, now let's talk about the people involved, the accused employees. Can you detail the legal actions taken against them? They seem pretty severe.
They are serious, yes.
The court documents name key engineers. Take Switchin Lee, for example, a former xAI engineer.
What happened with him?
He was hit with a temporary restraining order, a TRO, back in September 2025.
And a TRO is pretty serious. It's not a small slap on the wrist, no. This particular TRO was incredibly broad. It prohibited him from engaging in any generative AI role at OpenAI.
Wow. Not just working on similar tech, but any Gen AI role.
Correct.
That seems extreme. What does that imply?
Well, it strongly suggests that xAI successfully argued to the court, at least preliminarily, that his institutional knowledge was so pervasive, so deeply interwoven with their core secrets.
That it couldn't realistically be walled off, even if he worked on a totally separate project at OpenAI.
Precisely. The risk of inadvertent disclosure or use was deemed too high by the judge issuing the TRO.
Okay. And who else was named?
Then there's another engineer, Jimmy Freicher. He's accused of something more specific, harvesting xAI's source code.
Harvesting, like downloading it.
Yes, and allegedly copying large amounts of it onto personal devices before he left xAI to join OpenAI.
And when the court uses a word like harvesting,
They usually aren't talking about accidentally emailing yourself one file. We're likely discussing substantial volumes of proprietary source code files, maybe internal configuration scripts, details of training pipeline implementations.
basically the blueprints of their system.
That's the implication, yes.
Yeah.
The very core of how they build and run their tech.
Okay, harvesting source code.
Yeah.
That definitely speaks to the immense value placed on this specialized human capital, these engineers.
Absolutely.
But let's look at the counter-narrative, because OpenAI hasn't just sat there quietly, right?
No, definitely not. OpenAI has come out swinging. They vehemently denied the allegations.
What did they say?
They called the lawsuit baseless and framed it as, quote, the latest chapter of Elon Musk's ongoing harassment. Strong words.
Very strong. What's their core defense, technically speaking?
Their main argument seems rooted in employee mobility. They assert that xAI is, in their words, hemorrhaging talent, not just to OpenAI, but to other competitors too.
So they're saying people are leaving xAI anyway.
Yes, and that engineers have a fundamental right to change jobs without harassment, as they put it. It's a classic Silicon Valley argument about talent flow.
Okay, but let's push on that point a bit, because it's really central to how Silicon Valley works, isn't it?
It is.
If these highly paid, very smart engineers developed this proprietary code, this infrastructure, how can xAI legally argue that the knowledge itself belongs exclusively to the corporation
Right.
and not, to the human being who actually developed it and implemented it? Isn't that the tension behind decades of talent migration in tech?
That is the core legal question being tested here. Absolutely. xAI's claim hinges on the idea that the information allegedly copied.
The specific source code, the data center plans.
Right. That this constitutes legally protected trade secrets, something that goes far beyond an engineer's general knowledge, skills, and experience.
It's about specific documented IP, not just know-how.
That's the argument. And in this very niche field of foundational AI models, the competition is unbelievably fierce because, well, frankly, only a small pool of engineers globally really knows how to build these systems from the ground up.
Maybe just a few hundred people worldwide.
It could be that order of magnitude, yes. People with that deep end-to-end experience. So hiring even one experienced expert, even if it comes with the risk of a lawsuit,
Is often seen as faster, maybe cheaper in the long run than spending a year or more of internal R&D trying to replicate the same capability from scratch.
exactly. It's a high-stakes calculation companies seem willing to make.
It feels like the AI equivalent of, I don't know, the scramble for nuclear physicists back in the 1950s. You mentioned a parallel earlier to the Waymo versus Uber case from 2017.
Yes, the Anthony Lewandowski case.
Right, where a top engineer was accused of stealing thousands of proprietary files related to self-driving tech before founding his own company, which Uber then acquired.
Is xAI alleging something similar here, like theft of entire specialized code bases? They are. The core of the allegation isn't about an engineer using their general skills learned at xAI. It's about the alleged technical transfer of specific proprietary implementations.
The literal how of the model architecture and the deployment strategy.
That's what's alleged, the concrete blueprints, the code, the plans.
So what's the end game for xAI in this particular IP dispute? What are they trying to achieve?
Their objective seems pretty clear from the filings. They're aiming for, one, substantial monetary damages for the alleged harm.
Okay. Money.
But also, and perhaps more importantly, injunctive relief. Meaning court orders preventing OpenAI from ever using the alleged trade secrets and potentially barring them from hiring away specific mission-critical talent from xAI in the future.
So trying to stop the bleeding and claw back any advantage gained.
Essentially, yes. Trying to put the genie back in the bottle, legally speaking.
Okay, let's broaden our scope a bit because this fight over internal secrets isn't the only legal front, is it?
No, it's not.
Musk and xAI have also gone after Apple and OpenAI using antitrust law. That shifts the focus from inside the company to outside, to platform competition.
That's right. In August 2025, xAI filed suit against both Apple and OpenAI.
What was the claim there?
It alleged anti-competitive behavior, specifically centered around that big agreement to integrate ChatGPT directly into Apple's iPhone operating systems.
The idea being that this integration would create a kind of closed ecosystem, that it would unfairly restrict competitors like Grok.
That was the core of the antitrust claim, yes. That it leverages Apple's platform dominance to give OpenAI an unfair advantage.
Interesting. And what was OpenAI's main technical defense against those specific antitrust claims? Did they argue it wasn't restrictive?
Their defense primarily focused on the lack of true technical exclusivity.
Meaning?
OpenAI argued, basically, that xAI's own complaint contradicts itself, because the complaint acknowledges that iPhone users can still freely download and use competitor apps like Grok or access them via the web.
So the integration is just a convenience feature, not a locked gate.
That's OpenAI's position. They contend it's about user choice and convenience, not a restrictive technical barrier that prevents market access for competing chatbots.
Okay, so if we try to connect all these dots, the internal trade secret fights, the external antitrust battles, link it back to the broader market landscape. What does this web of litigation really tell us about the current state of the AI race?
Well, first and foremost, it underscores the sheer raw intensity of the competition right now. It's fierce.
You're kidding.
The lawsuits directly reflect the massive amounts of capital flowing into the required infrastructure. You see Microsoft, NVIDIA committing just billions upon billions to global data center expansion specifically for AI.
Right, the hardware race is just as intense.
Absolutely. And it also highlights how companies like xAI are making aggressive strategic pivots, for instance, targeting specialized vertical markets with products like Grok for government.
So they're seeking competitive advantage not just through having the absolute best general tech, but also through market specialization.
Exactly. Finding niches where they can offer a tailored advantage. It's a multi-pronged strategy.
And the outcome of this big IP dispute between xAI and OpenAI, it's going to have ripple effects, isn't it?
Oh, undoubtedly. The rulings here will set incredibly powerful legal precedents.
Precedents for what, specifically?
For trade secret protection in the AI context and for employee mobility rules for these highly specialized engineers. These rulings will directly influence the compliance frameworks, the hiring practices, the internal IP protection strategies for every major player.
We're talking Google, Meta, Anthropic. Everyone is watching this closely.
Everyone. Because the rules of engagement are being written right now in these courtrooms.
So wrapping this up, what does all this legal maneuvering, all this technical accusation and counter-accusation actually mean for you, the listener, the person trying to understand AI?
Yeah. How do you cut through the noise?
Right, this legal sparring. It's really far more than just a personal feud between billionaires or some corporate gossip column.
It's only not.
It is a fundamental fight over who owns proprietary large language model technology, who controls the critical data center architecture, and ultimately, it's defining the ground rules of competition in this new, highly technical AI economy.
I think the key technological takeaway here, the thing to really grasp, is that the value in AI today is becoming hyper-concentrated.
Concentrated where?
In the proprietary source code, yes, but also in those specific highly optimized operational advantages we talked about.
The custom drivers, the architectural blueprints for deployment.
Exactly. The stuff that cannot be easily reverse engineered or just replicated by throwing money at compute. It's this scarcity of the optimized code and scarcity of the human expertise needed to build and run it that allegedly drives companies to extreme measures, like poaching talent and risking these massive lawsuits.
Okay, that really crystallizes the technical stakes, and it sets up our final provocative thought for you, our listener, something to chew on after we finish.
All right, let's hear it.
Given these very serious allegations, claims that engineers are literally copying and walking out the door with highly proprietary source code and deployment plans. What are the technical limitations? Forget the legal documents, the NDAs, for a moment.
Okay.
What technical measures could AI companies reasonably deploy to make their foundational models, their core IP, mathematically and architecturally untransferable?
How do you technically lock it down?
Yeah. How could you make it so intrinsically tied to its development environment that a single departing expert cannot just take the crucial parts and replicate them elsewhere? Think about maybe custom hardware couplings or unique mathematical properties in the loss functions, things that fundamentally anchor the code and the model to the specific system where it was built.
That's a really interesting challenge. How do you embed non-transferability directly into the technology itself?
Something to think about.
Yeah.
That's all the time we have for this deep dive.
Fascinating stuff.
To stay updated on the latest in AI and ML, remember to visit our webpage, neuralintel.org, and check us out on YouTube as well. Thanks for tuning in.